Thank you very much indeed, Madam Deputy Secretary. It is a great pleasure now for me to welcome our third introducer, Professor Murray Hunt, who is a director of the Birmingham Center for the Rule of Law and a professor at Oxford University. Professor Hunt, the floor is yours.
Thank you very much indeed, Moderator, Madam Director, Madam Chair, Excellencies, ladies and gentlemen. It's a great honour for me to be with you all here this morning. I look very much forward to your discussions in this session. These are very challenging times for the rule of law, not just in developing countries or recently democratised countries, but in the well-established democracies. In the United States, from where I returned recently, the rule of law and judicial independence are constantly in the news. This week, the story is the assault on the legitimacy of the International Criminal Court. Last week, it was the calling into question of the decisions of US courts and prosecutors in the high-profile convictions of the President's former advisers. In my own country, the United Kingdom, the ongoing process of leaving the European Union following the 2016 referendum throws up daily challenges for the rule of law, including media attacks on judges as enemies of the people. Here in Central and Eastern Europe, as we saw debated in the European Parliament yesterday in the case of Hungary, there's a clear trend towards the assertion of political control of the judiciary, amongst other independent institutions which provide the crucial checks and balances to ensure that elected politicians do not abuse the very considerable power and trust placed in them by the people. These challenges to the rule of law cannot be attributed to individual political leaders, tempting though that might be. They're the product of much deeper forces and longer-term trends affecting our societies and our world. A resurgence of nationalism, isolationism and protectionism, the reassertion of national sovereignty, and a general retreat from multilateral cooperation and international obligations. As this week's elections in Sweden reminded us, there's an increasingly receptive audience for the xenophobic messages of political leaders which pose fundamental challenges to our human dimension commitments. In these troubled times, we need to recall the interdependence of the three foundational commitments to the rule of law, human rights and democracy. In particular, in this session of our meeting, we must remember that the rule of law is a precondition of the other two. There can be no democracy or human rights without the rule of law. We also need to remind ourselves of our shared responsibility for upholding these fundamental commitments. The rule of law, for example, is not the sole responsibility of the courts to uphold. It's the responsibility also of the other branches of the state, the legislature and the executive, to uphold and to promote the rule of law, as well as private actors and individuals. At this historical moment, when both the rule of law and some would say democracy itself are facing these existential challenges, I therefore want to focus my comments on the connection between two specific aspects of the rule of law that we're considering in this session, judicial independence and democratic lawmaking, in order to demonstrate this interdependence and shared responsibility. These are two important aspects of the rule of law on which OSCE participating states have adopted many detailed standards. So what does it mean that there is a shared responsibility for these aspects of the rule of law in practice? I want to ask two questions. First, what is the role of the legislature in upholding judicial independence? And secondly, what is the role of an independent judiciary in promoting democratic lawmaking? As we shall see, courts and parliament both have a strong mutual interest in upholding and promoting each other's constitutional function. And for a rule of law culture to grow and to flourish, there must be a clear division of powers between different branches of the state, with the legislative, executive and judicial branches responsible for different functions, and a clear and respectful understanding of both the limits of those functions and of the legitimate role of the other branches. So to turn to the role of legislatures in relation to judicial independence, how can parliaments contribute to the independence of the judiciary? Let's start with the obvious things that legislatures should refrain from doing because they undermine judicial independence. First, parliamentarians and legislatures generally should refrain from attacking courts and judges in terms which undermine their legitimacy. Courts and their decisions should not indeed be beyond criticism. It's important in a democracy that their decisions are carefully scrutinised, analysed and debated. But there's an important distinction between criticism and abuse. Individual judges should not be publicly vilified for their decisions, nor cast as enemies of the people. Criticism should be of decisions, not judges, and should be conducted in terms which are respectful of the individuals and of the importance of the independent judicial function in a democracy. Second, legislatures must refrain from passing legislation which subjugates the judiciary to the control either of itself or the executive. This is currently one of the greatest challenges facing the rule of law. Legislatures which are either controlled by executives which themselves want to control the judiciary, or which are complicit in such efforts by failing to scrutinise with sufficient rigour legislation which is designed to have that effect. So we see in a growing number of countries legislation being passed which confers too much power on political actors in crucial decisions about judges such as appointments, retirement, discipline, removal and deployment. These are both negative obligations on the legislature, not to undermine judicial independence. But there are also many positive things that legislatures can and should do to promote judicial independence. First, legislatures should put in place the detailed legal framework which ensures that neither the executive nor the legislature can control the judiciary, by ensuring that the framework guarantees security of tenure and contains the independent machinery necessary to protect the judiciary from interference by the powerful. Decisions about appointments, discipline and removal must not only be free from political interference, but they must be taken by bodies which the public can be confident are genuinely independent. And there is now a rich and well-established body of international principles on these matters for legislators to draw upon when they are designing this legal framework. Second, legislatures should rigorously scrutinise all government legislation which has implications for judicial independence, measuring it against the detailed international standards. They should seek expert help to identify both the issues that need scrutiny and the relevant standards, and should probe deeply the government's justifications for the legislation. Where necessary to secure compliance with such standards, they should amend the legislation. From my experience of many years advising the UK's Joint Committee on Human Rights, I know that there's enormous scope in every parliament to improve the way in which such scrutiny is carried out. Third, legislatures should hold the executive to account for its own responsibility to uphold judicial independence. They should monitor and scrutinise all aspects of government policy that can affect such independence, including budgetary matters such as judicial salaries and pensions, the amount of resources allocated to the justice system, and infrastructure questions such as court closures and the digitalisation of justice. In addition to this essentially reactive role, legislatures should be proactive in their scrutiny of the executive's responsibility for promoting judicial independence. An example of a specific measure which has proved effective in practice is the statutory duty that the UK Parliament imposed on the Lord Chancellor to uphold the rule of law and to protect the independence of the judiciary. When the Lord Chancellor failed to defend the judges against the media's characterisation of them as the enemies of the people, it was the chair of the Justice Committee in Parliament, along with other parliamentarians, who eventually forced a response from the Lord Chancellor, a member of the government, by invoking this statutory duty in questions in Parliament and in parliamentary committee correspondence. Fourth, in all this important work, legislatures should engage closely with the judiciary. Without seeking to hold them to account for their decisions, they should take evidence from them regularly about the operation of the justice system and should consult them about legislation or government policy which has significant implications for judicial independence, or the justice system generally. In the United Kingdom, the Lord Chief Justice regularly gives evidence to the House of Lords Constitution Committee, and other judges also give evidence to other relevant parliamentary committees such as the Human Rights Committee and the Justice Committees. Let me turn to my second question. Just as legislatures have an important role to play in upholding and promoting judicial independence, so courts also have a crucial role to play in upholding and promoting another fundamental aspect of the rule of law, democratic lawmaking. How can an independent judiciary make this important contribution? First, independent judiciaries should show restraint when necessary, so as not to encroach on the appropriate role of the legislature or the executive. They should demonstrate thoughtful consideration of the limits of their own function, so as to avoid unnecessarily calling their legitimacy into question. Second, an independent judiciary can help protect Parliament against executive usurpation of the legislative function. For example, in the UK, courts in the litigation around the EU's exit from the UK's exit from the EU forced the government to consult Parliament before it triggered the process under Article 50. This was a significant judicial intervention in the service of safeguarding Parliament's role when it was in danger of being sidelined by the executive. Similarly, an independent judiciary can also protect Parliament's role by ensuring that executive lawmaking, for example through delegated legislation, stays within the scope of the lawmaking authority that the legislature has delegated. Third and finally, courts have an important role to play as enhancers of democracy by encouraging compliance with the requirements that democratic lawmaking must be inclusive, transparent and accountable. They can incentivise such compliance by scrutinising legislation for compliance with such standards and being prepared to criticise the government or the legislature where necessary and justified for departure from such standards. For example, where there's been inadequate consultation of affected parties before legislating or insufficient time has been made available for the legislature to perform its important scrutiny role. And it's an important part of this judicial function that courts must also be prepared to apply a doctrine of due deference to the legislature when that is warranted, upholding challenged legislation which has been made in compliance with the requirements of democratic lawmaking and the fundamental standards the state is committed to. Ladies and gentlemen, I've sought to draw out some of the linkages between judicial independence and democratic lawmaking and to provide some good examples of good practice. I believe that it's by exploring these connections through the important lens of shared responsibility that we can best refine and develop our human dimension commitments and improve our procedures and mechanisms for monitoring their implementation. And I look forward to continuing to work with OSCE to redouble our efforts to meet the urgent challenges to the legitimacy of our institutions in these troubled